Federal Drive is presented by GEHA, Government Employees Health Association, proudly providing health and dental benefits to federal employees and their families. Visit GEHA.com.
And now, the Federal Drive with Terry Gerton, sponsored by GEHA.
Welcome to the Federal Drive on Federal News Network. It's Wednesday, December 10th. I'm your host, Terry Gerton, and I am glad you're here. Coming up on this hour of the Federal Drive, the EEOC powers up for swift action with full funding, a quorum, and new priorities. Plus, the DOJ ordered a sweeping data collection from U.S. attorneys on Trump-era priorities just days before Thanksgiving. Those stories and much more ahead during this hour of the Federal Drive. We begin with this. A federal judge in San Francisco is temporarily blocking the State Department from finalizing hundreds of employee layoffs. Foreign service employees were slated to be officially separated from the agency last week, but federal employee unions are making the case that state and several other agencies aren't fully adhering to a provision in the shutdown-ending spending bill. That provision temporarily blocked the Trump administration from carrying out layoffs. Federal News Network's Jory Heckman is here with more. Jory, thanks for joining me.
Hey, Terry. Great to be here.
There's been a lot of personnel news coming out of the State Department lately. Why don't you just give us a quick recap of all of the things that have been happening?
Yeah, a lot has been going on. The most recent development here has been the State Department trying to finalize the last bit of its reductions in force that began this summer. Back in July, the State Department sent RIF notices to about 1,300 of its employees, predominantly folks in the civil service, although a couple hundred foreign service officers were swept up in that as well. And the majority of these layoffs, these employees have already been officially separated from the agency. That happened back in September. Through some quirk or another, there were two different tracks of notice periods here. The civil service employees, by and large, got a 60-day notice between their RIF notice and when they would officially leave the agency. The foreign service employees, however, they got 120 days, so their separation date was going to be on November the 10th. However, November 10th came and went, and employees who were expected to be separated from the agency, they got a notice saying that they were going to have their administrative leave extended while the department addressed some administrative errors. The department hasn't ever really cleared up what those administrative errors were, but it's worth pointing out that those separations were going to happen towards the end, but still during the 43-day government shutdown.
The RIFs themselves began prior to the shutdown, though. So is there some confusion about whether the continuing resolution language applies to these RIFs or not?
Yeah, so there's been a bit of a Rorschach test going on with this reading of the continuing resolution and the provision in there that is barring agencies from proceeding with some layoffs, some reductions in force. Now, the text of the continuing resolution says that between the date of enactment, so November 12th, and the end of January of next year, no federal funds can be used to initiate, carry out, implement, or otherwise notice a reduction in force to reduce the number of employees within any department. That's the letter of the law there. Agencies, however, have taken a narrower reading of that language, and they said, all right, well, what that means to us, and this is contained in guidance from the Office of Personnel Management, all agencies, they will, if they sent RIF notices between October 1st, the start of the shutdown, and November 12th, the end of the government shutdown, they would rescind those RIFs. And that would be what they believe to be their obligation under the continuing resolution. However, there's now this added legal development where federal employee unions, the American Federation of Government Employees, and the American Foreign Service Association, as part of an amended lawsuit, this is the ongoing lawsuit that started at the beginning of the government shutdown, they are now saying in this latest chapter, well, wait a minute, State Department and other agencies aren't following the continuing resolution as we understand it to be, and so they think that state should actually be rescinding these layoffs that they were trying to finalize just last week, just last Friday.
What is the legal status of that case?
So these layoffs at the State Department are, as of now, officially on hold. judge in San Francisco, U.S. District Court Judge Susan Ilston, officially signed a temporary restraining order. Now, if that name sounds familiar, we heard her name quite a bit. She is the same judge that did block layoffs from occurring during the government shutdown, because this is, again, the same lawsuit that carried on throughout the shutdown, and still there are these loose ends to tie up now that the shutdown is over. And one other thing that these parties, these plaintiffs are pushing for here is they say that it's not just the State Department they're worried about. They say that agencies, including the Small Business Administration, the General Services Administration, and the Departments of Education and Defense have also not been fully implementing that layoff reprieve in the continuing resolution, and that they should actually be rescinding more RIFs than they have. SBA is one notable case where just last month they told folks that they were going to have their RIFs rescinded, and then a day later they said, oh, actually, we misread the legislation. Your RIFs will continue as planned, and sorry, they're not going to be rescinded.
There's a lot of whipsawing there for the affected employees. What are they saying, or what are the unions saying? What are the agencies saying about how this is going to roll forward?
Well, they really have raised concerns about the back and forth of it all, that the uncertainty for employees adds to an already tough situation. Layoffs are never a welcome thing for federal employees, and they are concerned about how seriously to take any of this news or any of these developments. And so the unions are basically telling agencies to consider a broader interpretation of this legislation and ultimately bring more relief, bring more rescissions than they have up until this point.
On top of all of this uncertainty, you've got news about a change in HR leadership at the State Department. What's happening there?
Yeah, so based on what I've heard from a couple of sources here, Lou Olowski, the Chief Human Capital Officer for the Bureau of Personnel and Training, he's stepping down from that role, but he's working at a different role within the department. He's going to be the Senior Bureau Official for the Office of Foreign Missions. TBD on when that change of title will actually take place, but I've been told that it is in process here. Now, Olowski is the name that has appeared on these RIF notices. He is the individual who has signed off on them, and actually what we saw back in July is his name appearing on some of the RIF rescissions that happened back then. Ever since day one, there were some hiccups where more State Department employees got RIFs than they meant to. And so there were some RIF rescissions on day one where they said, actually, sorry, you weren't supposed to get this. You still have a job here. But Olowski, this is a big part of what he's been doing at the State Department, overseeing these reductions in force. His name has also appeared before some of the court documents clarifying who can and who can't be RIFed, things of that nature. The American Foreign Service Association, going back to the spring, raised concerns about his appointment to be this top HR official within the State Department, because all of his predecessors in that role, they have typically been career members of the Foreign Service with decades of experience. That is just not the background that he has. He is new to the department, and so AFSA said that this is a position that doesn't match his qualifications. And so they were very concerned and made their concerns known to the public that Olowski was not a good fit for the position.
Regardless of fit or skills and background, what does this mean for continuity as the State Department navigates through all of these different personnel actions?
Yeah, it'll be interesting to see whether a change in HR leadership has anything to do with how the State Department has been carrying out what has largely been a year characterized by workforce cuts. Going forward, it's unclear what the State Department is going to do as far as hiring, as far as bringing new folks on board. It is worth pointing out that the Foreign Service did earlier this year begin hiring more classes of new Foreign Service officers at a time when it was also letting hundreds of them go. And so it's unclear yet what the trajectory of the overall Foreign Service workforce is going to look like in 2026 and beyond. But it has been a very dynamic year for the State Department workforce.
That's Federal News Network's Jory Heckman. Jory, thanks for keeping your finger on the pulse there at the State Department.
Thanks, Terry.
You can find his story at federalnewsnetwork.com. Up next, DOJ ordered a sweeping data collection from U.S. attorneys on Trump-era priorities just days before Thanksgiving. This is the Federal Drive with Terry Gerton on Federal News Network. Welcome back to the Federal Drive with Terry Gerton on Federal News Network. The Justice Department has directed all 93 U.S. attorneys to compile extensive data on enforcement mandates, including immigration, political violence, and sanctuary jurisdictions. Bloomberg Law's Ben Penn explains what triggered the move, what DOJ wants, and the implications for prosecutorial independence. Ben, thank you so much for joining me.
Thanks so much for having me, Terry.
You've reported on an incident that happened just before Thanksgiving when the Justice Department demanded a massive collection of data from U.S. attorneys. Tell us what they were asking for and why they got such a short deadline to provide it.
Yeah, so the Deputy Attorney General's office on the Monday before Thanksgiving asked all 93 U.S. attorneys' offices for a collection of basically data points, examples of all the cases that they're working on that show progress on a variety of White House directives and memos from the political leadership of the Department of Justice. And this was basically, it's not all that abnormal to do something like this, which is called a data call for the DOJ headquarters in Washington to seek statistics and basically hold the U.S. attorney's offices to the feet to the fire and show them, and give them, specific data points that demonstrate progress on some of the prior year's policy priorities. But this one did come across as a little bit grueling, given the timing with such a short turnaround. They were all told they had only 2 days before to turn around the data and respond by the Wednesday night before Thanksgiving, and just the sheer volume of all the data and stats that was being asked for. I did hear from folks that was a little bit noteworthy, but overall, I think what's interesting here is the request serves as a snapshot. It's sort of a window into what are the policy buckets that enforcement, in particular, that this administration is most keen to provide examples of to show the White House that it's fulfilling its objectives.
So you sound like there's two conflicting thoughts there. One is this is a normal end-of-year data call to kind of get a comprehensive perspective of all the work that DOJ has done over the past year, and yet they really had about a 72-hour timeline to do it. Did somebody forget to send the email 3 weeks earlier, or what's going on there?
I don't have any insight there. I will say that it could simply be, we could speculate as to whether the White House, given all that's been going on this year with the White House moving DOJ's agenda closer to its own, if it came from the White House asking to maybe expressing frustration about, why aren't there more cases, for instance, on lawsuits against sanctuary city jurisdictions, or where are our political violence cases pursuant to an EO executive order that Trump put out after Charlie Kirk was murdered. But we don't know for sure and it is possible that this is just to be a U.S. attorney is not an easy job, and having a tight deadline may just be part of the process.
You mentioned a couple of specific situations there that they were looking for data on. Tell us more about the investigation of organized political violence after Charlie Kirk's murder.
Yeah, so in September, and shortly after Kirk was assassinated, I called it an EO earlier. It was actually technically a presidential memorandum that came out and instructed the Attorney General, Pam Bondi, to basically ensure that there were cases that were being brought that specifically looked at organized political violence and domestic terrorism issues that have been priorities of the department in the past. But specific in this case, it seemed to direct a request for information about left-leaning groups like, and funding sources like the George Soros's Open Society Foundation, and to look at Antifa, and to try to investigate all the possible sources of organized political violence. So that was one of them. There was there was also a request for information on open cases that had a nexus to cartels or transnational criminal organizations, which stemmed from a Attorney General Pam Bondi memo back in February. There was also requests for all cases that are all examples of dismissals or cases that were closed in the aftermath of Deputy Attorney General Todd Blanche's memo earlier this year that called for basically scaled back enforcement of the cryptocurrency industry. Those are just some examples.
I'm speaking with Ben Penn. He's a senior reporter at Bloomberg Law. So what are the kinds of documents that DOJ should be expecting to get back from this data call?
Yeah, well, presumably, assuming all 93 U.S. attorneys' offices were in compliance with the deadline, they have basically, I would say it's both numerical and there are probably narrative examples of the types of cases that the department is in the midst of pursuing into cartels or into foreign terrorist organizations. But you would also see just counts of, say, all the U.S. attorneys' offices combined have brought, say, the X number of lawsuits against sanctuary jurisdictions, or have brought X number of cases under there was a specific request, for instance, to show the number of cases, criminal prosecutions of adults who sponsored unaccompanied migrant children. That was another recent policy from the Deputy Attorney General asking U.S. attorneys' offices to take a harder stance on looking for any crimes that an adult sponsor of a unaccompanied migrant child may have committed. So they're just looking to tally up all the examples that show how the extent to which the U.S. attorneys' offices are implementing what the administration wants them to be doing.
Given now that the data call itself is public knowledge, what would you expect to happen with the data as it's collected? Will that also be public, do you think? Or will lawmakers want access to it? And what conclusions will people draw?
I would love to provide some transparency into this, Terry. Unfortunately, I would not expect it unless anybody would like to disclose the results to me or to any other member of Congress or reporter. But the existence of this request was an internal email that I obtained, and I believe it is at the same time. I could see if the Attorney General, Deputy Attorney General are pleased with the results, you could see them highlighting it in sort of an end of year summary of success that we've had in enforcing the president's priorities. That's something that you would see, but there is no obligation for them to show their work, if you will.
And might Congress be interested in it as a matter of oversight?
Yeah, I could certainly see that. Whether both supporters or critics of this administration, would have an interest in knowing the extent of enforcement into political violence, into sanctuary jurisdictions, into cryptocurrency industry. That's all information that you could expect in an oversight request, or subject to the next time one of the senior DOJ officials is testifying on the Hill. We could see questions along those lines. I'm all about transparency. I would love to see as much robust data that shows what came of this request as possible.
I've been speaking with Ben Penn. He's a senior reporter at Bloomberg Law. Ben will be looking for your follow-up.
Thanks so much. Pleasure being here.
We'll post this interview at federalnewsnetwork.com/Federal Drive. Subscribe to the Federal Drive wherever you get your podcasts. Still to come, with billions spent on temporary border facilities, GAO says DHS needs a better plan. But first, the EEOC powers up for swift action with full funding, a quorum, and new priorities. You're listening to The Federal Drive with Terry Gerton on Federal News Network. Welcome back to The Federal Drive with Terry Gerton on Federal News Network. With full funding restored and a quorum in place, the EEOC is moving fast to enforce Trump administration executive orders. Here to discuss what employers should expect and how to prepare is Deborah Leader, partner in labor and employment at Ackerman. Ms. Leader, thank you so much for joining me.
Thank you so much for having me. It is a pleasure to be on the show.
I want to talk with you about the Equal Employment Opportunity Commission. They were pretty quiet during the shutdown, but they've got a full quorum now. They haven't had that in a while, and they've got funding. You work with them quite a bit. What do you think is going to change in the near term?
I think we're going to see a lot of changes, at least over the next several weeks, until there might be another issue with funding down the road. But I think that we can expect the EEOC to kind of come out of the gate running to accomplish some of these tasks that they have been anxious about doing since the current administration took fold in January of 2025. And so although there is now a new member who makes the quorum for the EEOC commission, the now chair, who was acting chair and previously commissioner, I think has made the priorities well known. And now that there is a quorum, the agency will actually be able to take official action and vote. Things of those nature will make a big difference.
So talk us through the priorities of the EEOC under this administration and maybe where there are major differences from the prior administration.
So we are going to see a lot of realignment and adjustment of where the EEOC focuses its attention and its resources. Some of the big ticket items for the new EEOC commission is to align the agency's policies with the executive orders that were issued, several of the executive orders which were issued in January of 2025 and forward. Those issues including the ferreting out DEI that may be counter to the law in the EEOC's view, as well as the pregnant workers protection regulations in the EEOC's view, maybe going too far from what Congress passed as the Protection Act for that, and also to maybe roll back certain protections for certain previously thought to be protected categories, including those of the LGBTQ plus community in terms of sexual orientation and transgender status, gender identity type things.
So those shifting priorities can come into play in a variety of ways. Do you anticipate more aggressive litigation on the part of the EEOC, maybe just more policy memorandums? How do you think those priorities will actually be put into practice?
I think in terms of priorities for the regulations, the rules that had been put out during the past administration, including the harassment guidance that was, I think, officially published in April of 2024, and the pregnant workers guidance, I think as a first measure or order of business, the EEOC is going to either do a wholesale retraction or an overhaul revision of both of those guidance for sure. And in terms of litigation resources, we'll be seeing more priority, pattern and practice, and systemic litigation targeted perhaps in ways that it hasn't been over the past few years, including to what the commission may view as like illegal DEI initiatives that employers may have, and then also helping to clarify its view of what, employers are obligated to do, especially in the area of religious accommodations and whether or not and how to balance religious accommodations versus other interests that are sometimes competing in the workplace.
So would you anticipate the order of those activities being first publication and education and communication about these new priorities or new angles on the rules, and then moving to enforcement?
I think the publication angle has already been well disseminated, even though the EEOC didn't have a quorum. Now Chair Andrea Lucas has been very vocal about what she sees as the driving priorities of the agency, and in her speaking, as well as in the budget that was submitted in May of 2025 in terms of where they're going to allocate the dollars to that. So I think the agency is already kind of gassed up and ready to go out of the station in terms of that. It's just how long will it take to undo some of these regulations, given that there is a commenting period and they're also, subject to court challenge, as we've seen in the past several years. So knowing that that might not be as fast a process as the EEOC might hope, we'll at least see a displacement of the disclaimer language and archived language we now currently see on the banner page for the EEOC. And it's either work under construction or, stay tuned for new upcoming guidelines. But in the interim, I think we'll see it in the way that the agency works on a day-to-day basis, how they accept charges, which charges they investigate fully, and which they may serve to litigate. And so that, as well as continuing to do the education and outreach to let the community know what the priorities are, what the EEOC is, expecting to spend its resources and efforts on.
I'm speaking with Deborah Leader. She's a partner in labor and employment law at Ackerman. Following on with that assessment of what the priorities are going to be and where you expect to see action, for the employers who deal with EEOC issues, what should they be doing in the near term to prepare for this change in focus from the EEOC?
Hopefully employers have already been staying aware of, on top of the changing priorities, the realignment from the current administration. And so being insightful, those employers most likely have already started to review their policies, to review their websites, to review their hiring criteria, as well as, how they handle compensation issues, and to just make sure that the policies are going to be step-in-step alignment with what the EEOC and what the executive orders have asked for. But in terms of really getting up to speed, aside from continuing to monitor what regulations may be updated, and not just, formal guidance, but we may see more enforcement guidance or Q&A type format from the EEOC to help employers get up to speed on doing that. Employers need to make sure all of their documentation has been reviewed and is ready in the event of what might be a very broad, all-encompassing request through the investigation stage of some of the EEOC's priority issues. So to just kind of, buckle up and be ready for that ride.
And so what will you be watching for as the EEOC really gets its feet under it and moves out? Are there particular cases or activities that you think are going to be significant here in the short run?
Well, the significant cases are waiting to see how the EEOC is going to interpret. We kind of already know, but from the Bostock versus Clayton County case in terms of transgender, gender identity, and sexual orientation protections, and whether or not the EEOC is going to, we know the EEOC in their updated guidance on harassment is going to remove those types of protections. We already know that the EEOC, I believe, has not taken any additional charges or is not investigating charges that assert claims on those grounds, although there's still a private cause of action to get a right to sue to bring those issues to the forefront. But bringing it back to what employers can do, they need to continue to be mindful of what might be the federal policies that they're seeing and how that might compete with various state and local laws that are also a moving target on a day-to-day basis, or at least a week-to-week basis. So employers definitely have a challenging thing, but as a lawyer and as the co-editor of my HR defense blog, which I have to put a pitch in for, we try to stay on top of all these issues and push out information that employers need to know.
I've been speaking with Deborah Leader. She's a partner in labor and employment law at Ackerman. Thank you so much for helping us understand the very complex environment here.
Thank you very much. I appreciate and enjoyed the opportunity to speak with you through these issues.
We'll post this interview at federalnewsnetwork.com/Federal Drive. Subscribe to the Federal Drive wherever you get your podcasts. Coming up next, with billions spent on temporary border facilities, GAO says DHS needs a better plan. This is the Federal Drive with Terry Gerton on Federal News Network. Welcome back to the Federal Drive with Terry Gerton on Federal News Network. GAO reviewed DHS and CBP's reliance on soft-sided facilities amid surging apprehensions and billions in contract obligations. Here to explain what GAO found, why it matters for cost and oversight, and what's next for border infrastructure planning is Director, Contracting and National Security Acquisitions at GAO, Travis Masters. Mr. Masters, thank you so much for being here.
Great, Terry. Thank you.
We're going to talk about a recent GAO report that's certainly timely, the use of the Department of Homeland Security and Custom and Border Protection's use of soft-sided facilities for joint processing centers. Tell us a little bit more about the situation and what motivated GAO's assessment of how this process is going.
Well, Terry, as you probably are aware, most of our reviews are initiated at the request of Congress. And so in this case, that was the case. The Homeland Security Committees in both the House and the Senate requested that we take a look at DHS's contracting and use of soft-sided facilities at the southwest border for holding apprehended individuals and processing them. In the 2019 through 2024 timeframe, the number of individuals at the border that were apprehended increased over that timeframe from about 850,000 individuals in 2019 to a peak in 2022 of about 2 million individuals. That's a lot of people. And CBP's facilities were dealing with overcrowding issues. And so they put these temporary tent-like structures known as soft-sided facilities up to help alleviate that. There was a lot of money associated with that as well. The cost for the facilities went from $170 million in 2019 to $1.4 billion in 2024. So given the numbers of individuals and the size of the cost, the Congress was interested in having us take a look at how those contracts were being managed and the facilities were being run.
In the course of this assessment, your team visited multiple sites. You went on site to see what was happening. What were the most significant findings about how CBP planned for and provided oversight of these facilities?
Yeah, we visited 4 facilities. At the time of our review, CBP had 7 total soft-sided facilities along the southwest border. We visited 4 of those, and we looked at 8 contracts out of the 69 they had for those. The primary takeaway for us in all of that was that there were areas where CBP could have done a little bit better with regard to analysis and planning for requirements for those facilities with regard to numbers of personnel needed for certain functions. For instance, porters, who are folks that move individuals' possessions around within the facility and other items within those facilities. As part of our review, we pointed out that they had, in some cases, too many individuals in a facility and in other cases too few. And they didn't really have a methodology, a staffing model methodology for helping with those fluctuations. And in fact, during our review, our questions about that actually prompted CBP to go back and revisit that, which resulted in a real-time savings, $2.7 million per month between August and March of 2025, August 2024 to March of 2025, for about a savings of $18 million. So, things of that nature. It was about doing better planning and having better analysis, it was really kind of the broad takeaway for us.
Simultaneous to your report, DHS received millions of dollars to construct additional hard-sided or permanent facilities. What did you find about the cost effectiveness of the temporary structures compared to permanent joint processing centers?
Yeah, so the permanent facilities don't exist yet. CBP, DHS is in the process of building the first one in Laredo. They received just over $300 million from the Congress in 2022 to build this permanent facility. What we found was similar in that sense, that the analysis and planning up front for choosing where that facility might go, how big that facility might be, lacked in some areas regarding requirements and cost estimating. Right? They made a decision to put the facility in Laredo. They didn't really document clearly the rationale or the criteria for why that was the location selected versus other locations, and they didn't have a comprehensive cost estimate in place before that. And so again, it really boils down for us to just doing good upfront homework to make sure that you understand that the investment you're making is well informed and that it's the most efficient investment and effective one possible, which again requires you to understand the requirements and things of that nature. So in that sense, they were similar, right? Both JPC and the soft-sided facilities needed some additional study up front.
I'm speaking with Travis Masters. He's a director for contracting and national security acquisitions at GAO. In the course of this assessment, GAO made 6 recommendations, documenting lessons learned, focusing on those life cycle cost estimates. Which of these do you see as the most important for DHS to act on right away?
Yeah, I think the lessons learned aspect, conducting the analysis necessary to kind of inform future decisions, is probably the biggest. We made some other recommendations as well regarding oversight of the contract and training of contract oversight officials, which are also important. But the lessons learned piece and the study and analysis piece regarding the Joint Processing Center, I think, are the keys. In March of 2025, CBP closed the soft-sided facilities that it had. The number of apprehensions went down. The soft-sided facility contracts were not extended. And so CBP kind of has an opportunity right now, now that there's sort of a lull in the number of individuals being apprehended, to take some time to think forward about, how would they plan for and react when numbers increase again? Because history shows us that the numbers do increase and decrease over time, and it's likely that the numbers will increase again at some point in the future. So we see that as really a target of opportunity for CBP to take some time to retrospectively look and document lessons learned so they can prepare for the future.
That's a great point. DHS did concur with all of the recommendations, but you bring up an important point about capacity. Do they have the capacity and the skill sets to do this cost analysis, to do this planning? What would it take for DHS and CBP to really fully implement your recommendations?
Well, just simply assigning the people to do the work, having an organization within DHS to take a look at the numbers historically, the contracts that were in place at the time, the data, very similar to the information that we collected and analyzed for our report, and then taking some time to sit down and look at. There are a number of best practice documents. We have GAO has best practices, for instance, for analysis of alternatives that we cite in the report that could help DHS as it plans for its joint processing center investments, figuring out what's the best alternative, cost-effective wise or requirements wise. And so just taking some time to sit down and actually do the analysis, and then we'd like them to document that. I think it's important to document those lessons, not just simply have them in some individual's head or maybe in a collective group of heads, but have it on paper for the future individuals that will have to make those decisions as well, so that it's memorialized.
DHS has other detention functions across other portions of its organization. Do you see a cross-fertilization of this skill set and making sure that they're considering the same factors as they're planning for other detention facilities?
Yeah, absolutely. I mean, I think these are just general, basic, good analysis, good informed decision-making kinds of things that would apply regardless of the organization. Our report was focused on CBP specifically, but as you know and others know, right, ICE also has detention facilities that it manages and contracts for, and I think that these same principles, these same ideas are applicable to them as well. Yep.
I've been speaking with Travis Masters. He's a director in the Contracting and National Securities Acquisition Team at GAO. Thank you so much for sharing this report with us.
Absolutely, Terry. Thank you.
We'll post this interview and a link to the report at federalnewsnetwork.com/Federal Drive. Listen to the Federal Drive on your schedule. Subscribe wherever you get your podcasts. The Pentagon's plan to fix its decades-old material weaknesses, specifically its inability to reliably track government property in the possession of contractors, is failing. The Defense Department Inspector General warns that if the services don't implement a department-wide solution soon, the Pentagon risks missing its goal of achieving a clean audit opinion by 2028. For more details, Federal News Network's Anastasia Obis spoke with Mark Thomas, DoD IG's supervisory auditor.
As this material weakness has been reported in the agency-wide financial statements for many years, recently in 2019, I would say, is kind of the time period from there going forward where some significant progress has been made, and that's when DoD got very serious about creating a corrective action plan that would address this specific material weakness. So in 2019, they created their first corrective action plan to try to solve this weakness. And then in 2021, OUSD also released a clarifying memo, and that was about the implementation of the GFP module. The GFP module is really the central piece of importance to the government property and possession of contractors' weakness. The GFP module is kind of OSD's planned solution on how they're going to be able to account for and track government property and possession of contractors at the enterprise level. So when you talk about what is the corrective action plan that DoD had, central to that idea was the implementation and use of the GFP module. So they put that guidance out, and they have working groups. The OSD has working groups with the components, with Army, Navy, and Air Force, and others. But they have working groups where they work through this and they talk through this. But specifically, the implementation of that GFP module is the key to getting this to work. And so when we talk about, well, the IG has identified that this is still an area that could be used for improvement, I think it's the actions that each of the components have taken or not taken to implement the GFP module in their tracking of the government property in possession of contractors. I think specifically, one of the technical challenges that they have is that each of the components, when I say that, that's Army, Navy, and Air Force, they have their own accountable property systems of record, APSRs, you'll see that in the report, where they account for their property. Part of what OSD wants from their corrective action plan is to be able to connect the APSR at the component level, their system, to the government-wide system, the GFP module. They want an automated connection there. And so that is something that the components have not been able to do yet. They're still working to implement that. Each of the components has corrective action dates for that are still into the future. So right now, there is a corrective action plan out there. We believe that the plan that they have, that OSD has, would work well to accomplish, mitigating this material weakness, but we need to get the components on board with connecting their APSRs to the GFP module.
Mark, correct me if I'm wrong, but the GFP module was not mandated as the department-wide solution. Did the DoD provide a reason or justification for why that is the case? Or maybe why has DoD leadership been unable or maybe unwilling to mandate the system?
Yeah, that's a good question. I don't have an answer as for why DoD has not mandated it, but I will say that I think that's what in our audit found that the OUSD could be more forceful in recommending and implementing this solution. And so I think that is one of our recommendations, is they need to be more direct in saying that we will use this module all the components will use this module. And so that was one of the areas that we thought was weak. The department could improve their messaging, and they could improve to be more direct in requiring the use of this module. And so that is one of our recommendations.
And then for the components, what is their justification for using their own solutions? Since they're not using this module, what is their reasoning?
So each component has different reasons why. Most of the reasons kind of center around the fact that these, each of their own departments, they have their own material weakness in this area as well. Each department, each component has their own financial statements, and they have their own material weakness in government property and possession of contractors. So they have their own systems which differ from component to component. So they have their own technical challenges and how their particular system in the Air Force functions and how it accounts for property versus how the Navy does it. So each group is kind of working on their own technical challenges and how they're going to report this into their own APSRs. And so they are busy doing that, and they are actively trying to clean that up so that they can all get opinions on their financial statements. But what we found lacking, and what our report pointed out, is that while they are focusing on remediating their own internal to their department material weaknesses, there's been a lack of focus on working with OUSD to mitigate this department-wide material weakness.
What was their response to the fact that now they have to adopt the department-wide solution?
We had positive responses from management on, adapting the solution. They have various technical challenges of IT challenges of how to actually make the connections from their systems to the GFP module. So that is something that they're all working through on their own timeline. I think they were receptive to it. They understand the importance of it, and they understand what this really would give is if there is a functioning GFP module across the department. This would really give the department a larger bird's eye view of all of the property that they have in the possession of contractors. And it would provide, that enterprise level look and ability to tell we have so much property at contractor X. And so that would be something that, that would be beneficial for the department, and it would push everyone forward to be more audit ready as everyone tries to become, audit ready by that 2028 financial opinion deadline.
Do your findings suggest that the services are at risk of missing that 2028 milestone?
Yes, I think our findings are, and that is essential to what we're talking about in the report, is that some of the timelines to remediate this weakness from the components are pushed out beyond that deadline. Unless there's a change in those dates, then they'll be at risk for missing the deadline.
That's Mark Thomas, DoD IG's Supervisory Auditor, speaking with Federal News Network's Anastasia Obis. You can find Anastasia's story at federalnewsnetwork.com. The Federal Drive with Terry Gerton is produced by Eric White and Michelle Sandiford. Our web editors are Daisy Thornton and Stephanie Wright. For the latest updates, stay with federalnewsnetwork.com or follow us on Facebook, YouTube, and LinkedIn. I'm Terry Gerton. Thanks for listening.